So why don't you contact the civil department, you notice up your motion. Ms.
Okay.
Jackson, I'm assuming you're talking about summary disposition, counsel?
Possibly, yes.
Okay, all right. Ms. Jackson, what counsel's telling me, and I know we speak our own language, so I'm gonna try to break it down.
It's okay.
What counsel's telling me is she assumes based on the discovery she's going to do that she is going to be in a position to file a motion with the court. Motion is just the word we use in this business for request. So she's going to request that I give Canton a judgment based on the law that applies because there are no factual disputes with the law that applies. You'll get a chance to look at that written document. You'll get a chance to respond to that written document, both in writing and then orally for a hearing date. If at that hearing, I grant their argument, in other words, I buy their argument, I'm going to enter a judgment. If I don't grant their judgment, do I have that on?
You might not. I think they already removed it.
Yeah, I think it's gone. Counsel, you got something ready?
Yes, I have 2 cases ready for you.
Which one you want to start with?
We'll do Lori Binder, LVNV funding versus Lori Binder.
All
Case
right,
number
your
ending in
appearance, please.
1306. Good morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff.
Thank you. Ms. Binder, you can hear us okay?
Yes.
Thank you. Counsel, what do we have for Ms. Binder?
For this case, we request a 60-day adjournment. She apparently is working with Beyond Finance, whom we have worked with on multiple cases. And it's always a good end result for all the parties, but they have not contacted us yet. So she will be giving them our contact information. So hopefully it'll be settled.
So we'll just schedule another pretrial 2 months down the road?
Please.
All right, Ms. Binder, any questions?
No, not today.
All right, wish you luck.
Thank you.
Have a good day.
You too. Bye-bye.
Thank you. Counsel, you also ready on best?
Yes.
All right. Ms. Best, go ahead and unmute.
Hi, how are you?
It's Mr.
Mr. Best.
Mr. Best?
Yes.
All right. If you have a camera, go ahead and activate it. If you don't, we'll go along with audio only. Counsel, what do we have today?
Good morning, Your Honor. Lynn Olivier, appearing on behalf of plaintiff. In this case, Your Honor, the parties have agreed to the entry of a consent judgment for plaintiff and against defendant for the full amount as paid for in plaintiff's complaint, and that the defendant shall pay the judgment in installments of $50 each month beginning August 1st, 2024. I will be emailing, or my office will be emailing to the defendant a consent judgment to sign, hopefully through DocuSign, to sign and return so that we can file that with the court as soon as possible.
Thank you. Mr. Best, are those the terms you've agreed to?
Yes.
Any questions about how that works?
No, no questions at this time.
All right. We'll sign it as soon as we get it in our electronic file.
All right.
Good luck to you.
Thank you.
You're welcome.
Your Honor.
Is that it for you, counsel?
I have 2 more at 9 o'clock, so I'm going to log out and I'll log back in at 9.
Thank you.
Thank you.
Then I have another one in a breakout room, Judge. It's Sharonda Jackson. The attorney is Sheila Siegel. Canton,
what case is
Canton
that?
1, the very first one on the docket, Canton 1 Limited.
Okay. And they're in a breakout?
They're in a breakout room, yeah.
Ms. Siegel, your appearance, please.
Good morning, Your Honor. Sheila Siegel, appearing for Canton One Limited, plaintiff on behalf of attorney record Kenneth Cohn.
Thank you. Ms. Jackson, if you've got a camera activated, if not, we'll do audio.
Okay, we'll just do audio because every time I get on camera, it kicks me out because I'm around my job at the plant.
No, that's fine. That's fine.
Okay.
Counsel, what do we got today?
Your Honor, we did have a nice conversation. We're not going to be able to settle it today. There may be some opportunity to settle it in the future, but we do need to get some dates, including for discovery or time.
All right, so you want me to just adjourn the pretrial with some discovery time, or what do you want to do?
Correct. Yes,
So how long? 60 days out for another pretrial?
that would be fine. And to,
Okay, and I'm assuming written discovery only?
yeah, that should be fine at this point.
Okay. All right, Ms. Jackson, a pretrial is an opportunity for me to get some information about the file so we can hopefully move it towards a resolution. I'm just going to adjourn the pretrial. Discovery is an exchange of information. It's supposed to be a two-way street. So counsel's probably going to send you a list of questions she wants answered. You can do the same. If there's documents that you think that Canton has in their possession that you need to prepare your defense, if there's questions you want answered, you can communicate all that with counsel. Understood?
Yes, Your Honor. I do have a quick question though. We did this the last time we were on the call and there were supposed to be some documents and things sent to me, but I didn't receive any questions the last time. We did this and posted it out for 60 days. So I'm just trying to understand, how long is it gonna take to talk to the leasing office? Because even when I was living there, I had a hard time getting a hold of them. And it seems like
Your
the
Honor.
attorney's office is having the same issue.
Your Honor.
Okay, counsel?
Yeah, I mean, we've followed the protocol and if we had some informal discussions. So we've tried to work with her. I don't think that's appropriate at this time, but we will follow the court's requirements and we will exchange information.
I don't have any requirements. I don't have any requirements. You
No,
asked for discovery.
No, I will, the court's deadlines to do so. So that's all I'm saying.
Okay, all right. So do you want to just set it for trial or motion? I mean, I don't want to set another pretrial if you guys don't think you need it.
You could set a dispositive motion date too, but we'd like formal discovery, so.
Yeah, no, I'm giving you the discovery. So why don't you contact the civil department, just notice up your motion. Ms.
Okay.
Jackson, I'm assuming you're talking about summary disposition, counsel?
Possibly, yes.
Okay, all right. Ms. Jackson, what counsel's telling me, and I know we speak our own language, so I'm gonna try to break it down.
It's okay.
What counsel's telling me is she assumes based on the discovery she's going to do that she is going to be in a position to file a motion with the court. Motion is just the word we use in this business for request. So she's going to request that I give Canton a judgment based on the law that applies because there are no factual disputes with the law that applies. You'll get a chance to look at that written document. You'll get a chance to respond to that written document, both in writing and then orally for a hearing date. If at that hearing, I grant their argument, in other words, I buy their argument, I'm going to enter a judgment. If I don't grant their judgment, if I don't buy their argument, then we're just going to move forward to a trial date. Do you understand that?
Yes, Your Honor.
Do you have any questions?
No, sir.
All right, so I'm making a note. We're going to do written discovery for approximately 60 days out. Counsel will contact the civil department and actually schedule a motion date.
That will be the call of the attorney of record, but I can't rule that out. But yes, Your Honor, that's correct.
Okay.
All right.
All right. Have a good day, ladies.
Thank you very much. You too.
Thank you.
Judge, there's something on the docket, Hearst versus Galindez.
Yeah,
They're
it's supposed to be live.
downstairs. Oh, okay. Jamie's
live.
asking me. Okay. Do you want them
Yep,
sent up to the
yep.
courtroom?
Well, yeah, because I'm going to swear in Mr. Galindez and then I'm going to send them out to have their accredited
That's what I
exam.
figured. Okay. Okay.
Thanks.
Yeah, so what she's telling me is she can't make that decision. That's for the attorney of record is that to get motion. So I mean, probably just schedule it for a pretrial. If they contact us beforehand, they want to do a motion, we'll just do the motion. Okay, that makes sense.
Yeah.
Okay. They just have Mr. Galindez, so they're waiting for the other party.